All right, we are the Armed Attorneys. Today, we are coming to you live with more of your questions answered. We love these segments. We really like doing them live, and so we hope you enjoy the discussions that we have. If you do, show your support for the Second Amendment by hitting that like button. And this is where you get your questions answered. So if you have any firearms, self-defense, Second Amendment related questions, the perfect place to leave those, the comment section. We got them right here in front of us, and we'd like to talk to you about them. Now, we already picked out a couple of questions that we sourced from previous discussions. If you have a question, especially if you're watching this on the replay, just type your question in there. That's where we source all these things.
Yep.
We have a ridiculous story about Everytown suing a mom and pop gun shop out of business. We're going to talk about that just for a little bit. Then we have some follow-up questions to this Illinois safe storage law and these anti-gun politicians. We have a lot of things to talk about. Emily Taylor, how are you?
I'm better now than I was this morning. I was standing in the line outside the courthouse in Galveston trying to get in the Texas heat of the summer at 9 months pregnant. So I'm a lot better now.
Yeah.
That I'm doing this instead of that.
Well,
how about you, Richard?
I'm fantastic. I almost chopped my finger off this weekend, but we're recovering. We're on the mend. So I wanted to start this off with a ridiculous story we got out of Bloomberg. They say anti-gun nonprofit targets mom and pop gun stores. So this is Everytown and Perkins Coie helped Maryland sue the district.
We got this out of Wall Street Journal.
Oh, sorry.
Yeah.
Yeah, but it's Bloomberg's anti-gun.
Yes.
Sorry, I misspoke there. And the District of Columbia sue law-abiding retailer. What's going on with this?
Yeah, so this is just one of those things. I don't think it was really worthy of a whole episode, but United Gun Shop in Maryland. This is just one of those ways in which the process is the punishment, right? That's lawfare. That's what lawfare does. And so what happened was they rigorously complied with all of the Maryland and federal background check laws, everything they're supposed to do. I mean, like virtually every FFL I know, they're incredibly diligent about following the rules because you don't follow the rules, you lose your license and your livelihood. And they very diligently followed the rules, and someone abused the rules. I mean, he filled out all of his paperwork the way he should have. He got his collector's license in Maryland such that he could buy firearms a little more frequently. And they sold him guns totally legally, and he was trafficking them to a convicted felon who was then trafficking them on the black market. And little did this gun shop know that he was doing that to like a bunch of stores in the area. And so you would think that the government would say, aha, let's punish the bad actor here and move on. But they did not.
No, they go after the mom and pop gun shop. And, in most states, what we have is called an intervening third party. Like, is some other party's criminal acts an intervening cause to, let's say, a lawsuit you have against this gun store? And if the answer to that is yes, well, the gun store shouldn't really be on the hook for what criminals do. There's a really great quote out of a Supreme Court opinion, criminals pick their victims.
Mhm.
They have complete control over all of these things, and so we shouldn't hold these parties that are acting lawfully responsible for the conduct of criminals. And so, this stuff really gets my ire up, but it's lawfare.
It is lawfare. So, and they somehow, and I'm not really sure how this works because in Texas it wouldn't work this way, but somehow Maryland contracted with Everytown for gun safety in order to litigate this lawsuit. Again, I do not know how that works. I do know that probably taxpayer funds were going to that group, which is horrifying. But just what a travesty. And ultimately, the district court was like, nah, dismissed the case, cited the PLCAA, the Protection of Lawful Commerce in Arms Act, because they sued under like nuisance theory and negligence theory, which not allowed to do. That's what the PLCAA was made for. And now Maryland is appealing that lawsuit. So this poor mom and pop shop is having to expend even more money to fight the appeal, which is just, it's horrifying.
No, but
I wish I was a Maryland lawyer. I wish,
The goal was run them out of business. It seems like mission accomplished. Way to go, Everytown.
Yeah, right.
This doesn't make us more safe. We got a couple of questions. We'll pick these up in the comments section, and we'll go to some pre-prepared questions. Chicken fried rice, can you please explain why people like the common use argument? Isn't that a trap for anti-gunners to stop future unpopular arms? I think that is a fantastic point, because if it all hinges on, hey, is the item in common use? Well, we could make, do a little circular argument here to
Uh-huh.
make these things not in common use. Therefore, they're not in common use and you lose your right to keep and bear arms. I think that's a very good argument.
That's a yes, absolutely. We tend to like it right now because we're using it against things that are in fact in the common use, and then all of a sudden an anti-gun legislature is like, aha, let's ban people from using this thing. And so we like it. But yes, turnabout is fair play. I do think that there is a significant anti-gun argument that could come from that common use language. I mean, I don't want to give any ideas.
Sure.
I don't want to give the other side any ideas, but like that is an excellent point.
Well, I skimmed the headline. I didn't read the whole article, but did you see the thing about Canada studying why there's only like a 10% compliance rate with their, they went and seized a bunch of guns.
Oh, I did not read that article.
Well, it's like if you can't get Canadians to comply, like good luck doing that in America.
Yeah, fair enough.
So we think. All right, next one. This is from Robert Thornton. He had a question about has anything changed with deferred adjudications in getting your Texas license to carry? Texas specific question, but I think it's worth discussing. The way that the Texas DPS treats deferred adjudications, they say we're going to treat these things as convictions for purposes of licensing. What is a deferred adjudication? It's when a court defers a finding of guilt, doesn't find you guilty so long as the person does everything they're supposed to do. They release you without a conviction. So it's great. I mean, it's a great way to not have a conviction on your record. But for licenses, they treat them as convictions. Nothing has changed in that regard. And then we still have kind of a list of deferred adjudications where even if a substantial amount of time has passed, they are going to say it's a forever prohibition. And that's on our burglary crimes. That's on our
Title Fives.
Yeah, Title V. So felony Title V offenses. So that would be like aggravated assault or something like that. So
crimes against your persons.
So that hasn't changed. Now, there was a push this last legislative session to kind of shorten that list substantially. It would say robbery, aggravated robbery, but not robbery, for example, or burglary, but not burglary of a habitation. So there are efforts to kind of shore these things up. Deferred adjudications, those are for folks who are deserving of a second chance. We shouldn't have a lifetime prohibition on them getting a license.
No, we shouldn't. And we file bills, not us specifically necessarily, but there are bills filed every session that would help that. And we've yet to see one get across the finish line, but we can only hope.
Yeah.
Should we go to one that's pre-prepared?
Yeah. This came up from our last discussion, and we were talking about this Illinois, or actually this video came out just on Friday.
Oh, yeah.
Illinois passed a very wild safe storage law that relates, they've kind of redefined what making a firearm accessible to a child is. And I think big headline here is they don't care on the dischargeability of a firearm. They care about access to firearms. So even if this thing is completely inert, unloaded, maybe even with a cable lock, maybe that's the safe storage law still gets invoked. And so the question they had was, if you're carrying a firearm and your child is sitting next to you, let's say in a vehicle, would that law apply to you? What was your reading of it?
So my reading of the actual legislative text is that if it is on your person, that it is not, it is being construed as being inaccessible to the child. So if you are actually carrying it on your person, it probably is safe from the safe storage law. Generally speaking, when we think about who is in possession of any item, right? Firearms, illegal drugs, things of this nature, we think about care, custody, control, and management. So to whom can we ascribe those things, right? If something's in the center console, you could potentially argue that it is in either party's care, custody, and control and or management. If it is holstered on your body, good evidence that it is in fact in your care, custody, and control. If it's in my purse and I'm carrying my purse, but then I hand my purse to Richard, and Richard's not my husband, so he's not really in the business of carrying my purse in public.
I've done it before.
He's done. But then you have like potentially the issue of, okay, it went from my possession to Richard's possession, easy peasy. Whereas if it's on my body, it probably stays in mine. Yeah, so I see that as the issue here.
Yeah, and there was kind of a little bit related to this. This is from Douglas. He said, wouldn't that be a violation of the Heller decision? So I thought that this was a really fascinating take on it, because what do we get from District of Columbia v. Heller, talking about the right to keep and bear arms, they're talking about inside your home, castle. So maybe there's a little bit of an overlap here, but also it's for the purposes of, defensive force, self-defense. Is this really implicated, do you think?
So, so we have the issue, which is that the case or controversy directly presented to the court is the only one that has any legal and precedential value. So we have lots of phenomenal dicta from Heller. Phenomenal. We look at the prefatory clause of the Second Amendment. We look at the operative clause. We decide the operative clause, in fact, includes your right to carry a gun for armed confrontation. Obviously, but it's the first time we've had that in writing from the Supreme Court of the United States. Great. And that seems like you would say, oh, well, that should include your car. That should include all sorts of things.
Right.
It would logically follow. However, the actual law challenged in Heller was having to keep that firearm inoperable within your home. And so the actual narrowly tailored holding of Heller applies only to your home.
Yeah, and I can see it because when we talk about castle doctrine, a lot of states have gone a step further and say, guess what? Your home, that's not your only castle. When you're in your occupied vehicle, that's an extension of your castle. Or you're at your place of employment or business, we're going to extend the castle doctrine protections there. The Supreme Court didn't bring up those issues in
Right.
DC v. Heller. They were really specifically focused on the habitation. So if we wanted to see, hey, is this a unconstitutional infringement on the Second Amendment, this safe storage law inside of my vehicle, the court would have to address that separately.
Yes, and you would brief the hell out of it. And
Yeah.
you would be like, look at this language from Heller. Look at this. And you would argue essentially that it logically follows from things the Supreme Court has said that this must be unconstitutional. But it's not unconstitutional until a court says it's unconstitutional. We can
Yeah.
all know it in our hearts, but legally and technically not until the courts say. So that is a phenomenal question. And I love getting the chance to address that because there's lots of people who, like, we talk about these things and they jump on and they give us a really hard time. Like, they're like, these stupid lawyers, you won't see an unconstitutional law. And it's like, no, we see something that is likely to be held unconstitutional
Right.
or unlikely to be held unconstitutional, but we don't get to make that decision. And unfortunately, like, the
Well,
courts make it, and until the courts make it, like, what are you going to do about it?
well, and it stinks to ever have to give this answer, and we have to do it a lot. But it's like, obviously we don't want any infringements to the Second Amendment. But what the courts do, the courts are their own little animal, and we can't force judges to do the right thing every single time. I mean, we can try our really sticking hardest, but when we say, hey, here's the current state of the law, that's really what we're talking about when we say, here's what the courts have done with this thing. So, all right, this one is directed at you, Emily. This is from Joshua. He says, Emily, how do good lawyers not become blackpilled and burned out on dealing with these with the disingenuous on a daily basis?
Oh boy. Um, I don't even know where to begin answering that.
It's like pushing a rock up a mountain.
It is because you get it from all sides. You get it from all sides. And it is just yeah. I mean, it's a great question. Also,
You just gotta be a happy warrior. That's my
yeah, it came with $5. We will answer all your money questions. That's how Samir over there is getting paid today. He's like, thank you. But yeah, I mean, that's, I mean, I would say probably most of us spend a lot more of our conversations than we would like to trying to be human lie detectors
Yep.
with almost everyone. So, I mean, that sucks if you're, my husband or my children. Less so if you're the AC repairman trying to sell me a bill of goods for something I didn't need.
Sure.
That's, probably works to my benefit. But yeah, it's tough. It's really tough. I don't have a good answer for that. It's a great question. It happens, but
All right, I got one from Joseph. He says, question, if a state passes constitutional carry, does that mean I, as an out-of-state resident, can legally carry there? I.e., I live in Texas, I want to drive to Florida for vacation. So
depends.
here's the answer. You have to look at how that state has worded its constitutional or permitless carry law. From what I understand, it seems like virtually every state has chosen to not make a distinction between residents and non-residents. Some states have, though. I think Louisiana or Louisiana. I don't think they care.
I don't remember.
there's one of these states, maybe it's South Dakota. All right, one of these states out there I know specifies that you have to be a resident of that state. I don't think Florida says that. So obviously you would want to speak to an attorney licensed in the state of Florida to make sure you're on the up and up. The one quirky thing about Florida, and I don't know why they can't fix this, they prohibit open carry, which is
Mm-hmm.
kind of bizarre just because people inadvertently open carry all the time. You're getting out of a vehicle, you're grabbing a box of cereal off the top shelf in the grocery store. Uh, People shouldn't be getting in trouble for stuff like that.
No, they should not. So this is an interesting question. This is a good vibes adventure. In New York State, they still ask on the permit application, what is your reason for wanting a pistol permit? Is that a violation of Bruin's 2022 decision on good and proper cause?
Probably not,
Probably
as
not.
long as they aren't using it as a criteria for issuing the license.
Correct. I mean, they can ask any question. I mean, the Texas DPS asks questions they are not entitled to the answers to. They can ask you anything, but if you say double birds because I feel like it, they should
If you meet all the other
issue
requirements,
you a license if you
right.
meet all the other requirements, because that's all Bruin requires, is that it not be a
May issue state.
it not be a may issue state. It is a shall issue state. So hypothetically, and I'm not a New York lawyer, but hypothetically, you should be able to write self-defense. You
All
should be able
lawful
to write,
purposes.
yes, I would like it for all lawful purposes. I would like it, you know, to stand up against tyrannical government,
Sure.
what have you. They should still issue you the license if you actually legally qualify otherwise. But I don't know what New York's doing, and I wouldn't be surprised if they were being abusive.
Yep. All right. This is a pre-prepared question. This is from Paul Wilson, 8627. Can law enforcement or the property owner do a cursory search if they suspect you are armed on private property? So let me lay out kind of hypothetical scenario. You're entering in, let's say, a private business. Owner says, maybe I think this person is carrying. They ask, can I search you for firearms? Can they do that?
Well, so this says law enforcement or the property owner.
Yeah, let's do two
So
different ones.
there's two different ways about it. So the property owner, I mean, look, if someone is not a peace officer or occasionally a magistrate, I mean, check your state's law for who can actually give you lawful orders. You don't have to listen to nothing. So if you're just on private property and they're like, hey, I want to search you, or you're my employee, I want to search your vehicle and see if you've got these things on you. I mean, pound sand. Now, can they trespass you from the premises? Sure. Can they fire you if you're an employee? Sure. But there's no legal requirement. You consent to nothing. They don't have any rights. If someone's like, I want to search your car or I want to search you, like, I mean, even if it is law enforcement, I'm going to say, no, under zero circumstances. Walmart used to do that. Remember? They
Yeah.
used to say, are you carrying when you walked in? Which was like, oh no, do you have an LTC when you would walk in with
Right.
your, when you were open carrying?
Yep.
And that, like, you don't have to answer that question, but also if you don't answer it, you're not going to shop at Walmart that day. They're going to kick you out. So now law enforcement can actually, I mean, they can do a Terry stop anywhere, right? You're inside the Walmart. I mean, they can pat you down for their safety, right? So now if they ask for consent to search anything, you should probably say no. But if they have the lawful authority because they have reasonable suspicion that you might be armed in a way that could make you dangerous to them, yourself, or to the general public, they're gonna, regardless of where you are, they're going to pat you down.
But the other part that I wanted to talk about with this is, there is because we're talking about private property rights. You as a private property owner, you don't have to let nobody on your property, right? And you think about this more in context of like sporting events or music concerts or things like that. Consenting to a search might be a condition precedent to you gaining entry to the property.
Mm-hmm.
So if you decline at that point, the property owner, the way they deal with that is they just refuse entry. So I mean, there's kind of the second part to that.
Yeah. Here, we've got a good one. This is Ferdinand de Bull. Question. Also, yes, when you type question, I'm sorry, there's someone kicking me from the inside right now. When you type question really big there, it does help us to see this as we are going through. Oh, no, I'm sorry. Oh, that's not the one I wanted to pull. Well, now we'll have to do yours too. But I wanted to pull Crispy Bacon. Would a criminal defense attorney like yourself be capable of defending someone who is being sued civilly from a self-defense case involving firearm? If that is a situation you're in, you need to check and make sure that your civil lawyer is capable of handling a gun case, or if you're looking at a gun lawyer, they are capable of handling a civil case. So, me personally, I am not capable of handling a civil case. Richard, he is and does.
Yeah,
So,
and I'm actually very surprised. You have criminal law, civil law, but even within those things, just like doctors, attorneys, and they don't like us using terms specializing, but
no,
there's a
we're not
there's
allowed
a
to say
type
that.
of case that I think I'm more capable of handling than another, right? It's not a specialization. But a lot of these, especially in civil cases, these civil lawyers, they never really think about the logistics of self-defense,
No,
how justification plays into liability,
no.
other than maybe some just general defenses. Hey, this person, you know, uh, was the cause for whatever happened, or the person contributed to their negligence or things. But most states have something in their law built in that adds protection should you act in like justified defense or something like
Yeah.
that. You need somebody who understands how these things kind of
Yes.
fit together.
Because ultimately they're going to be arguing your justification
Right.
under the self-defense laws in the civil courts. So you really need someone who is capable of doing both. Not everybody, like I said, I am not. I don't take civil cases.
Well, and
So
the other thing is too is, and most of the time civil cases come after a criminal case. But it's like there are definitely criminal law implications to a justification claim in a civil case. There's no statute of limitations for murder. Your civil deposition doesn't go fantastic. Well, have you opened the door to now being prosecuted for murder?
right.
I mean, there's a lot of different things going on that you
Yes.
really need to be aware of. On top of, and this is really specific to Texas, but what our law provides protection for a person who's justified under our self-defense statutes in our penal code. So really, the people who understand those justifications most of the time are going to be criminal defense lawyers. So there's a lot going on here, but you want to make sure your
Yeah.
lawyer is equipped to handle it.
And then I will handle Ferdinandable real fast. 'Cause
Okay, let's hear it.
That was a tease. For home defense rifles, such as semi-automatic rifle, are FMJ rounds reasonable self-defense rounds? Yes, absolutely.
Yeah.
Absolutely. Yeah, I wouldn't worry too much about that, except with the knowledge that whatever you have, if a prosecutor's going to go after you, they're going to try to use that against you. They're going to try literally anything at their disposal. See Kyle Rittenhouse. They did try to use that against him, but it was just ridiculous. I don't think even any member of the jury bought it. I mean, obviously they didn't say acquitted him, but yes, don't worry about that. Use what is going to keep yourself and your family safest. Let us worry about your choice of ammunition.
All right, I'm gonna ask this question to Emily. This is from Andy. It's a super chat. I
Oh,
appreciate the super chats. If you
yes.
want to get your guaranteed your question answered, that's how you can do it. Who swears the most in your office? Just confirming the suspicion.
I'm not going to answer that question.
I'll confirm the suspicion. Yeah, it's Emily. Obviously, it's Emily.
No.
She's got a sailor's melt on her. Come on.
I am trying to reform my ways though, because my oldest child is now about 3, and her little brother knocked something off of a table the other day, and she stomped her foot and she threw up her hands and she went, "Oh!" and then ended with a very creative series of expletives that I'm certain I have used. But then I said, we're not going to tell her daddy that, and we're going to clean it up around the house.
Well, it's like you say please and thank you around your kid all day long. You ever hear those? No. You say
Mm-mm.
one, mother, whatever, and the kid, they can't help themselves.
They can't
It's
help
the damnedest
themselves.
thing. All right, here's another question that we had. Um, this is from DMBCD. Have we had a question from him before?
I don't know.
Okay, it looked familiar. Hey, I have a question in regards to the Second Amendment and anti-firearms politicians when it comes to firearms law. How are politicians able to pass blatant unconstitutional laws regarding firearms? I live in Commie, California, so you can understand while I'm asking this question. Yeah, no, it's tough. You see these lawmakers, are they passing something that is within the ambit of the Second Amendment? Yeah. Is it clear on its face that this is an infringement? Yeah, well, guess what? New York State Rifle and Pistol Association v. Bruin. This thing should be on its face flat unconstitutional. Why do they get away with that stuff?
Well, it's sort of like what we were talking about earlier, which is that, yes, blatant unconstitutionality aside, who decides that? The court system. So, is it within our control as the people to stop an unconstitutional law before the courts? And the answer to that is tar and feathers. I mean, because as long as the lawmakers pass it and most of the
They get
time,
elected, they pass it.
right. I mean, as long most of the time we're talking about the police enforcing it, right? So
Right.
when we're talking about guns, we're generally talking about the criminal law. So lawmaker gets elected, lawmaker passes the bill, governor signs it into law, police enforce it. I mean, realistically, and I know that we like to stomp our feet and say unconstitutional, but until a court decides or we start taking matters into our own hands, those are our two options, right? So, I mean, shall not be infringed, unfortunately. Like, I wish that was like a weapon I could wield physically in my hands against the government. It's not. That's a weapon that's wielded on paper after something bad happens.
Yep. All right, I got a question here. This is from Joshua Cornelius. Why is SCOTUS kicking the can on high capacity magazines and sporting rifles legally? All right, we gave Justice, was it Barrett we were giving a hard time? Or was it
It was Kavanaugh.
So I've heard two competing theories. I like both equally. Um, there's a lot of politics that happen behind the black robe in the Supreme Court.
Mm-hmm.
I think, and this makes the most amount of sense to me, I don't think they had the votes, and I think it was just a political decision. That that assumes no ill intent.
I assume ill will.
Yeah.
Yes. That is an excellent question. It is quite possible that they don't have the votes, and so they are kicking the can until they do. Um, it is quite possible that I don't know. I don't know. I don't see anything changing in the composition of the court in the near
Other than them
future.
getting like the right facts or something like that.
Right. No, I mean like the composition, like the
Right.
justices, right? So I don't see the composition changing in the near future. I skeptically, I think that they limit the number of really contentious things they're going to take session by session. And you start dealing with some of the things that we've dealt with this session in terms of like, my gosh. I mean, I don't even know. I don't know what YouTube's going to start
We'll just
keying in on words for.
sure.
There's a little bit. So anyway, lots of dicey things were decided this session. So you don't know. You don't know. I'm more skeptical.
Okay, I'm gonna handle this one from Brad. Question: Can a state pass a law and then charge you for something that happened before the law was passed? This is what has happened in at the United Gun Shop. So, yes, we're talking about ex post facto laws. These are criminalizing conduct that, maybe a person did X, Y, Z with a certain mindset. Today we pass a law. Can they go back and pass a law that would affect that conduct? It really depends. And this is like a really intense, constitutional law discussion. We see this happen a lot with statute of limitations.
Mm-hmm.
They'll pass a law, it'll sit there with a teeny tiny statute of limitations. Think about, kind of all the assault cases coming out of New York that are, violent. We'll just leave it at that. They go back and say, we're removing the statute of limitations. And now it opens up the floodgates for all these things. Is that an ex post facto law? There is a test. The Supreme Court has a test. It's going to depend. I'm not equipped to give y'all a full rundown of it, but it's not as simple as, hey, this wasn't a crime when I did it, so I can't be punished for it. It's a lot more tightrope.
It is. Now, you always hope that
That's something you argue, right?
Yes, you always hope and argue. There are always exceptions to the exception. So, and bear in mind that none of the arguments for the takings clause helped us in any way when something that was legal but you possessed became illegal. Think bump stocks, think arm braces for pistols, think literally anything the ATF has done recently. You would think that had some sort of ex post facto component to it, and yet it did not. And then everyone who made a takings argument was laughed out of the courtroom. So there we have it.
Yeah. So make sure to post your questions in the live chat right now. We're going to be handling just a couple more questions. So if you want your question answered, make sure to post it there. If you haven't already, like that video and share the show with your friends. That helps us fight the anti-2A algorithm. Just a little sidebar complaining about YouTube just a little bit. If y'all are watching any of the gun channels, there's been some downward pressure by YouTube, especially in the past maybe 6 weeks or so. So it really, really goes a long way.
Yeah, it does. It's been really pretty unfortunate, but I haven't saved it, so I won't give you a shout out to your name, but someone was like, isn't lawyers' time too expensive to do this kind of Q&A? Well, first of all, we're not real lawyers, we're gun lawyers. So,
Sure.
um, but the answer is like, kind of, unfortunately, like, YouTube isn't very lucrative to begin with. This definitely doesn't make us any money. We just really like it. I mean, I like to think it's something of a public service,
Yeah, well,
but
and if y'all aren't familiar with the origin story of the channel, I mean, we started this during the coronavirus times because we were kept getting the same gun law question over and over and over again about carrying while wearing a mask, and we just thought, man, if we just put
we
out a
could save
video,
ourselves some time.
save us some time. So it was almost out of necessity. Really, we're trying to put ourselves out of a job. We don't want gun owners to get in trouble, make you hard to convict kind of stuff, make sure folks are on the up and up with their gun laws. These things are always changing. And so, yeah, we know it's expensive, but in the long run, it's a public service.
I think we enjoy it. Okay, Alan Rutherford wants to know. Okay, this is a Texas question. I live in Texas. I have my CHL. If I'm in the back seat of a vehicle, the driver is stopped. They ask me for my ID. Can I tell them to pound sand and exercise my fourth and fifth?
Yeah,
Yeah,
big time.
yeah. Now, Edwin and I actually had this disagreement on a video a couple weeks ago. So you've got your LTC and you're carrying. There's no punishment for telling them to pound sand. Technically, that law is on the books that you should present both to them. Weigh your options, decide which one you want to do. Both are appropriate because there's no punishment on the books for telling them to pound sand. So just decide whether or not you want to, what you feel like dealing with that day.
Right.
So,
All right, this one I have is from Sentinel 1099. If silencers are removed from the NFA, do they cease to become firearms under the law and therefore lose protections under the Second Amendment since they aren't needed to be used for a firearm? It's kind of an interesting twist.
that is an interesting twist. So they are specifically notated in the US Code as firearms, which has worked in our favor in terms of making a Bruin argument. However, the government never ceases to exploit literally anything.
Right.
And the government right now is the one that is making the argument that, well, suppressors aren't firearms, therefore not protected under Bruin, therefore we can do whatever we want with suppressors, which it cuts both ways, right? You don't get Bruin protection, but then if it's not a firearm, well, then go back and regulate it some other way, guys.
Yeah,
Figure it out.
I
And
think,
you're not going to be able to do it.
well, I think where we're at right now, let's say January 1, 2026, the $200 tax goes away. We have this big beautiful lawsuit from the folks over at Gun Owners of America to basically dismantle the National Firearms Act with regard to suppressors, short barrel rifles, shotguns, and AOWs, because guess what? This whole justification of the NFA scheme is based on taxation. Well, the tax has gone away. Theoretically, these regulations, these infringements should go away. All right, well, what happens? Let's say we get what we want. Those things that part of the NFA completely dismantled. I think we're going to default back to suppressors being just gun control firearms as defined in the United States Code.
Yeah. So we've got at JCS 1069 question. Do you think that the Hughes Amendment will ever get overturned? I'll pay the $200 and do the paperwork to get lower cost MGs. I actually thought the Hughes Amendment was going to be the first NFA brick to fall. I thought it would be the first.
Yeah,
And here we are. It's not going to be the first. But yeah, I definitely think the Hughes Amendment's going to fall.
and so what we're talking about is, we have a limited supply of machine guns here in the United States, pre-86, things that were registered in circulation, kind of this artificial supply limitation. I have seen, I mean, there are these machine gun groups, and there's law enforcement agencies, from what I understand, that have machine guns that weren't registered in compliance with the National Firearms Act, but, they're still able to legally possess them because we have these exceptions. Trying to get these firearms back into circulation, I think that's probably going to be the first win I think we see with machine guns, is maybe the supply of machine guns opens up, as opposed to, completely tearing down the NFA and
Right.
getting rid of the tax and all these other things. So that supply issue, I think it's ripe.
I do too. I mean, that's what I mean. I think, my initial guts told me that Hughes Amendment would fall, then suppressors, then maybe short barrel firearms. I think we're going to see it the opposite way. I think we're going to see suppressors and short barrel fall, and then Hughes. And then, I mean, at that point, come on.
Yeah.
Why are we still regulating fear mongering from mafia days? So
Yeah.
we'll
All
see.
right. Specific question from Doug B. Can I own a gun after a Class C family violence deferred adjudication is completed? Not specifically talking to your specific case, Doug, not your lawyer, but you'll want to speak to your lawyer about this. But a person in Texas, Class C misdemeanor deferred adjudication for an assault, or, it's an assault family violence case. If there is no adjudication of guilt, no affirmative finding of family violence because you haven't been adjudicated, for a person that should not serve as any disability to a person's firearms rights to purchase, possess firearms, whatnot. If a person completes a Class C deferred in Texas, they can actually get their case expunged. So that's a
Yes.
physical deletion and destruction of all the records. You do that through, it's called an expunction. It's kind of like a civil lawsuit. It's not as much work. I mean, it's work for the lawyer, not work for you. But
It's a civil lawsuit I can handle. That'll
yeah,
tell you something.
yeah, we can handle those, but you'll want to get that expunged. You don't want that hanging around.
Yeah, it's expungible after 90 days. So if you plead to a deferred adjudication, Class C family violence, you should have your full firearms rights. You still want to get that expunged because what the government's going to do, both the DPS and the FBI, when you try to go buy a gun, is hang you up on it and
Yeah.
say, I see some sort of family violence case here. And then you're going to have to say, hold on, it's not disqualifying. And you have to go through all sorts of appeals processes at any moment. So just shred the documents is what you want to do.
This is actually, I think this is a really, really fun question. You may or may not like this.
Uh-uh.
Bo G, is it unusual to ask an attorney his or her political affiliation before retaining them?
Oh, well, not for us.
No,
We could
not for
ask,
us.
yeah.
People ask us that all the time.
Yeah. I would say for most attorneys, it is probably unusual.
But you walk in, nose ring, purple hair. Do you have to ask?
I mean, it is, I will say, it is often nice to be on the same side of the political aisle as your client because you can like kind of, you're just chatting like I was chatting with my guy in the, hallways of the courthouse today. You've got something to talk about, particularly when it's an issue like firearms, which is very politically driven. I think you want to know that your attorney is very, very motivated to keep your rights as opposed to,
Yeah, can you
signing them
imagine?
away
Yeah,
potentially
can you
for
imagine?
you.
You're charged with a crime. It's a gun crime, and the lawyer that you have hired, or maybe the court's appointed you, hates guns.
Hates guns.
Yeah, what does that look like? That can't be in that client's best interest.
No, it certainly is not. So yeah, I mean, I would say generally speaking, I mean, unfortunately, we've had to hire lawyers for things before. I've never asked any of them, but it's never been a particularly politically sensitive issue.
Yeah,
So, I mean, I think it's probably unusual, but people ask us all the time, and I'm glad they do. I'm happy to.
yeah,
And if that's part of your process for vetting your attorney, like,
doesn't bug me.
doesn't bother me at all. I'll tell you where I stand any day of the week.
Yeah. All right. Well, I think this is a good point to wrap it up. But we hope you enjoyed this discussion. If you did, consider subscribing, hitting that like button, and help us fight the anti-2A algorithm by sharing this video.
Yes, and if you are viewing this after the fact, still leave questions because we will still mine for future episodes here. And thanks for joining us, y'all.
Yeah, this is so much fun.
Yep.